Good morning, good afternoon, good evening to all of you from around the globe who are joining us for today's webinar. This is the 7th in the series that was launched 4 months ago by the World Commission on Environmental Law, or WCEL, of the International Union for Conservation of Nature. Welcome and aloha from my home here in Hawaii. My name is Denise Antolini. I am honored to be the Deputy Chair of the World Commission on Environmental Law. I am a professor of law at the University of Hawaii at Manoa, William S. Richardson School of Law. On behalf of WCEL, I want to express my gratitude for the speakers and all participants who have joined us today for the 7th webinar in our WCEL webinar series. And it's the first in a new series jointly sponsored with our partner, the Global Judicial Institute on the Environment. This is a 2-part high-level series entitled Recent Developments in European Environmental Law Jurisprudence. The second part, Webinar 8, will be held on September 4th. The speakers, as you know, are world-class on this topic, and we encourage you to register for the second webinar as well. So I will introduce in just a minute the chair of the World Commission on Environmental Law, Justice Antonio Benjamin, who will turn it over to Dr. Bruno Oberle, who is the Director General of the IUCN. And then he will introduce Dr. Christina Voigt, Professor of Law at the University of Oslo. And then we'll turn it over to our distinguished moderator, Lord Robert Carnworth, and our amazing panel today. But first, let me cover some housekeeping so that you all can engage. A minute for first about the World Commission on Environmental Law. So WCL is one of the 6 expert volunteer commissions of the IUCN. WCEL is a, as I said, volunteer network of environmental law and policy experts from all regions of the world who contribute their knowledge and expertise and services to the IUCN and our many partners. We have over 1,300 members, many of whom are attending today's webinar, which has over 300 participants registered from around the world. So please go to our WCEL webpage for more updates, news, and resources, including a wonderful series of environmental law lectures and recordings and information on past webinars. Today, we are very honored, as I mentioned, to co-host this session with the Global Judicial Institute on the Environment, and Dr. Voigt will tell you more about the Institute. I do want to acknowledge 3 key founders of the Institute are with us today. We're very fortunate. Justice Benjamin, Lord Carnworth, and Dr. Luc Lavriesen. We're really grateful that they've helped organize this webinar and put together an outstanding lineup of speakers. So let me cover some housekeeping as a way to introduce you to how to engage during this webinar. First of all, if you're a registered participant and you're online now, at the bottom of your screen, you have a chat box. So please keep an eye on that chat box because we will be posting information, we already are, and links from time to time during today's webinar. We will communicate to you using that chat box. For you to communicate with us, you want to use the Q&A box, which is also at the bottom of your screen. So if you take a look now, you can open up that Q&A box, and you can let us know at any time during the webinar if you need some kind of technical assistance, but most importantly, that's where you can type your questions. So we encourage you to type short questions to our panelists, to our moderator, and we will organize those and get them answered at the end of the webinar. I do want to mention that we are recording today's webinar, and we will share this recording with everyone who's registered as well as posted on our website. So the PowerPoints, the other materials that the panelists wish to share will be posted on our website probably within about a week. And then feel free to share this with colleagues because it's intended to be a public educational resource along with our lecture series. I want to briefly introduce and acknowledge the assistance today of our behind the scenes staff. It really does take a lot of people to put these webinars on, and we're very fortunate today to have the assistance of Emily Gaskin, who is the Executive Officer for WCEL and an environmental lawyer, and Olivia Bonner, a recent LLM graduate of Pace University and an environmental law specialist at the United Nations Environment Program. So thanks to Emily and Olivia and many others for their assistance today. Let me also add that we're very fortunate to have professional interpretation today in French and Spanish. We want to thank Etienne Van Damme, Claude Argot, and they are providing interpretation in French. Camila Oyan and Jorge Milazzo are providing interpretation in Spanish. If you have not already turned on your interpretation, you can select the globe icon at the bottom of your screen. Select your preferred language for the entire webinar. We are really thrilled that this type of interpretation allows us to have even broader engagement across the globe. Before I turn it over, let me mention something about the WCL's World Environmental Law Congress that we had planned to hold in Rio in March of this year. As many of you know, major international events, including the World Environmental Law Congress and the World Conservation Congress, have had to be rescheduled. But out of that difficulty, we have found opportunity. And with these major in-person events postponed, we have learned how to innovate, to connect our members across the world through webinars like this. So we encourage you to continue to connect through webinars, Zoom meetings, and other platforms as we press forward on urgent environmental law conversations, sharing our amazing expertise among our members and partners, and moving toward a just transformation of conservation law and policy. Thank you for joining us on this endeavor today. And now with that, oh, one more thing. I must add that the views expressed today are not the views of IUCN, the official views of IUCN or the World Commission on Environmental Law, or even the Global Judicial Institute on the Environment. These are the views of the individual speakers, and this event is purely educational and we hope inspirational. So now with the housekeeping out of the way and these general introductions, thank you again for joining us. I'm very pleased to turn this over to my dear friend and colleague, the chair of the World Commission on Environmental Law, Justice Antonio Benjamin. He has been the chair of the commission for the last 8 years and done an amazing job. All of this while he's on the High Court of Brazil, the STJ, and serving as a world recognized jurist and leader in the field of environmental law. So he will now give some opening remarks, and I welcome him to the webinar. Thank you, Antonio.
Let me begin thanking my dear friend, Professor Denise Antolini, for her leadership in many aspects of the work of the World Commission on Environmental Law, but particularly in respect to organizing and taking the lead in this WCL webinar series. The webinar that we begin today, divided into 2 pieces, is a highlight of this series. And it is a highlight because first, it shows the very best of IUCN, and we have here its Director General, Dr. Bruno Oberli, but also it represents a recognition of the importance of judges vis-a-vis the environmental rule of law. I believe we all understand and agree today, but it has never been the case in the past, that we cannot protect the environment and conserve nature without the strong presence of judges. But it's not just the physical or the formal presence of judges. We need judges that are fully informed about the science behind the environmental crisis that we face. and no other institution as IUCN can provide this type of robust knowledge, unbiased, about this crisis that we all have to face. The second point that I would like to make is that when I first proposed the establishment of the Global Judicial Institute on the Environment 8 years ago, I didn't expect it to come to life in such a short period of time. We all know that judges move slowly. We are the keepers of the status quo. It is hard for us to change and accept changes. But to my surprise, in less than 3 years, with the contribution of colleagues from all over the world, several of them here present, including my brothers, Lord Robert Carnwath, Justice Luc Lavrison, Judge Marc Clement, and the other, many others that are in their home countries at this right moment deciding environmental cases, we were able to bring this idea to fruition. And to me, this is a major transformation because it takes away the feeling of being alone of judges. So judges that decide or have a responsibility to decide environmental cases feel that they are part of a global family. A global family, not just because we know each other, but because we deal with issues that affect the whole planet. My last point has to do with the challenge that we face as judges. Judges cannot protect nature by themselves. Judges need strong constitutional and legal provisions that allow them to protect nature and life on the planet. But judges also need knowledge, and not just scientific knowledge, but legal knowledge, because rules, laws, constitutional provisions that are in the books and are not known or well known by judges, they are nothing. They are just a piece of paper. So the challenge that we face here in this webinar is a piece in this mosaic of attitudes and work that is being done. The challenge that we face is to provide good knowledge, unbiased knowledge to judges around the world. Working with partners, IUCN is one of them. The United Nations Environment Program, the Organization of American States, the Asian Development Bank, just to name those that have been working together with WCL in the establishment of the Global Judicial Institute on the Environment. So again, many thanks to Professor Denise Antolini, to the team of just two people of WCL, Emily Gaskin, and to all speakers of those two pieces of the webinar, and to all participants from around the world. I see here that we, in the list, that we really have the whole world watching what we are doing today in this couple of hours of frank discussion on European environmental law and justice. It's my pleasure now to invite Dr. Bruno Oberli to speak on behalf of IUCN. Dr. Oberli is someone that has been working with environmental policy and with environmental law, although he denies this, the second part of it, but it's unavoidable, for decades. He is a former minister of the environment of Switzerland. And we know if you can be a good minister of the environment in Switzerland, with that mosaic of cantons, language, diversity, you can provide good service for judges and for those that want to apply the constitutional and environmental laws that we have around the world. But to me, the most important thing that from those almost 10 years as Minister of the Environment that he brings is the knowledge that he has about the importance of good governance. We cannot protect the environment if we don't have good governance in place, if we are surrounded by corruption, if we are surrounded by myth and just by the status quo. So, Dr. Bruno Oberli, we are delighted to have you here today.
Thank you, Mr. Benjamin. Mesdames et Messieurs, Señoras y Señores, ladies and gentlemen, thank you for hosting me here at this important panel. IUCN, as you know, is an old organization, an old lady amongst the NGOs that works on the protection of nature and natural resources, 70 years old. IUCN is a big and very complex organization. IUCN is 1,000 and roughly 300 NGOs members around the world. In every countries of the world, we have members that works day for day on the ground, protecting the environment. IUCN is a dozen of governments member in the organization and almost 200 governmental institutions, agencies, and other institutions that bring the point of view of the structured institutional world to this discussion at the same level like the NGO members. And IUCN is thousands and thousands, more than 16,000, I was told, of experts in all type of knowledge fields that offers for free, like the speakers today, their expertise, their knowledge, their wisdom, their insight in the protection of nature to the organization and therefore to the colleagues and to the members. So IUCN is a community. IUCN is a union. And one of the fundamental roots of this union is the common understanding that to protect the nature, we need to understand the nature. We need to rely on sound science. We need to rely to the best expertise available. We have to get back to clear facts, and this will make our position, our advocacy, strong and influent. Of course, based on this knowledge, we want to deploy an advocacy activity that is brought forward by our members. We want to give in the hand of our members elements that allows them to make the case in their own part of the world in the issues that we commonly have over the world. And doing so, making political noise, making clear what is at stake and what are the ways to solve the problem. They prepare the way to create sound policy and therefore sound legislation on the environment, on the protection of nature, on the respect of natural resources. And preparing this way, creating the laws, they prepare the way for judges to use these laws, to use the influence of this community implicitly in all judgment they do. And it is important that we are aware, as Antonio Benjamin just said, that all of us, you, the members, myself, we are part of a community. We are part of a community that shares values, shares concern, and shares solutions. And it is important that we all together progress in understanding, in action, and in judgment. It is important that we exchange, and such an event that gather together experts from all around the world is one example of this sharing of experience. This is what IUCN is a community that shares knowledge and act together, each one at his place. And I am very thankful to the member of the WCL, and in particular to the person that have organized this seminar and are today here sharing their wisdom with the others for having done this. Thank you very much, and please continue doing and working for nature. Shall I introduce Dr. Vogt, or do you, Denise, do it? I have contradictory information.
I am honored to do it. Thank you so much for your wonderful remarks, and I just want to, I'm sure on behalf of the entire membership of WCL, say how delighted we are that you are in place and off and running and already engaging with the members in such a direct way. We really greatly appreciate it.
Thank you,
now,
Denise.
yeah, it's a real pleasure. Now it's my great pleasure to introduce my dear friend and colleague, Dr. Christina Voigt. She is a renowned expert in international environmental law and a professor at the University of Oslo. She has published widely on many topics and is a frequent speaker at international and national law events. She has worked as a legal advisor for the government of Norway on many international agreements, including in particular the United Nations Framework Convention on Climate Change, in which she is a leading negotiator and a major player. She is, in her WCEL role, the chair of the Specialist Group on Climate Change. And we are so pleased that Christina can help us, reintroduce everybody to the webinar series and help us kick this off. So over to you, Christina. Aloha from Hawaii to Oslo.
Aloha, everyone. Thank you very much, Denise, for this very kind introduction. And Dr. Oberle, my heartfelt congratulations to your appointment as Director General. We're all looking very much forward to working together with you. I also would like to warmly welcome everyone to today's webinar. It is a very encouraging sign that so many, currently it's 181 participants have logged on. It is just pays tribute to the fact that today's topic has attracted a large audience, and it is something that unites us in our common course to promote the environmental rule of law. Today's webinar, as already mentioned, is the 7th webinar in a range of, or the whole series of webinars organized by the WCL. And what started out as a COVID-19 contingency plan for not being able to meet in person and have conference and seminars organized, what started out as a backup plan has become such a successful story for the WCL. The previous webinars that we held were on such timely topics as ocean conservation in the Asian Pacific region, that was the most recent one, or judges as guardians of water resources. It focused on the Brasilia Declaration of Judges on Water Justice. We had a webinar on climate change in the courts, and we looked at using environmental tools to address the current global pandemic. And we had audiences as large as 500, 700 persons at the time, altogether more than about 2,500 participants that we have been so privileged to have with us over the course of those 7 webinars. Among them, high senior officials and high-level decision makers, in addition to judges and students and academics and everyone interested in the environmental rule of law. And by this means of webinars, the WCL has been able to promote the environmental rule of law across the entire globe. Today's webinar, as the first part, and the second part on September 4th this year, will focus on recent developments in European environmental jurisprudence. And it contributes, of course, to these success stories and fits very well in the list of relevant and timely topics. Because we are currently witnessing a turn to courts on environmental issues, especially on climate change, but not only on climate change, across the board on environmental challenges. In Europe, there are hundreds of cases pending or already decided that deal with various aspects of environmental protection. We have cases in supranational courts like the Court of Justice of the European Union or the European Court on Human Rights, but also in many national and subnational courts. The situation addressed is often that governments do not live up to ambitious action needed and required to protect the living space on which we all depend. And the question is, what can the judiciary, what can the third pillar of power legitimately do in this situation? In this context, it is very important that courts and that judges who sit on the benches, the persons, the individuals, that they know of each other and that they understand each other and that they speak to each other and that they speak the same judicial language and have access to sound scientific information, because they're all faced with many of the same challenges and are seeking solutions to effectively promote the environment. And this is the function of the Global Judicial Institute on the Environment, which both Professor Antolini and Justice Herman Benjamin already mentioned. This is the function the Global Judicial Environmental Institute seeks to fulfill. And we are honored to co-host this webinar together with the Global Judicial Institute on the Environment. The Judicial Institute is a signature initiative of the WCL and its partners, and it was established only 4 years ago, as we already heard. And it is a global network by judges, for judges, dedicated to the advancement of the environmental rule of law in courts and tribunals around the world. And now, without any further ado, I would like to introduce the moderator for today's webinar, our dear friend, Lord Robert Carnworth. Lord Carnworth is a former justice of the Supreme Court of the United Kingdom. He is a wonderfully active member of the WCL and a tireless advocate for the environmental rule of law. Dear Robert, the floor is yours.
Thank you, Christina, for those kind words. It's a real privilege for me to be involved in this, and I'm very grateful to my very good friends, Denise and Antolini and Antonio Benjamin, who I've been working with for some years. They've included me. Now, the subject is about Europe, and I'm wondering whether I'm here under slightly false pretenses, because, first of all, as you mentioned, Christina, I'm a former justice. I retired from the UK Supreme Court in March, a few days before we went into lockdown, so it's been an odd year for me. But also, I have to accept that my country has decided to leave the European Union at the end of this year. And my judicial career really, I mean, my legal career goes back to the early 70s when we joined the European Union, and now we seem to have come full circle. But I thought we've got 4 excellent speakers, and I'll come to those in a moment. But I think it's important by way of introduction, just to remind ourselves of what we're talking about when we talk about European law and European jurisprudence. Because in fact, different sources, as these speakers were making clear, we think, of course, of the European Union, which is the strongest body and has now 28 members, only 27 from the end of the year, but it is the law under the European Treaty and the subsequent acts and treaties amending that. It takes effect not only at European level, but also directly in the various member states. And so, as a Supreme Court judge of the UK, I was recently giving an order to enforce air pollution limits laid down by European legislation. And the Court of the European Union is the Court of Justice of the European Union in Luxembourg, with judges from the different member states, and their rulings are binding throughout the European community. In fact, environmental law is quite a latecomer to the European law in that sense. The original treaty said nothing about the environment, but the courts developed concepts of environmental law, and the Commission as part of the process of harmonizing the trading laws. And so one got, for example, the laws about environmental impact assessment without any specific provision in the governing treaty. But that changed in 1987 when we had the Single European Act, which brought in for the first time specific provisions requiring environmental laws to be instituted. And since then, there's no doubt that Europe has built up a very comprehensive and effective set of environmental laws governing everything from, as I say, air pollution through water to waste and so on. And I think it's one of the great achievements, actually, of international environmental law that these countries have pooled these resources. And I sincerely hope and believe that when my own country leaves the European Union, we will maintain those standards, and that's, as I understand it, is the government's intention. We'll then be looking also at the European Convention of Human Rights. Now that is has a different source. It goes back to 1950. It's the product of a body called the Council of Europe, and it encompasses a much larger number of countries. I think it's something like 47 countries, going well beyond the members of the European Union. There's a different court, which is the Court of the European Court of Human Rights in Strasbourg, and we'll be hearing something about their jurisprudence. There again, the original convention said nothing about the environment as such, but it has taken the sort of imagination of lawyers and the court over the years to develop concepts of environmental law, particularly through Article 2, which protects the right to life, and Article 8, which provides protection for the home and private life. And we'll be hearing about some of that jurisprudence in due course. And I'm happy to say that for the moment, my own country will remain party to those provisions. And then, of course, one mustn't forget other European instruments. We'll be hearing about the Aarhus Convention, for example, which is the product of a different organization. That's the United Nations Economic Commission for Europe. It's called Aarhus because it was in that Danish city, which I probably pronounced wrong, that it was first enacted in 1998 and has since been ratified and adopted, I think, in, again, something like 46 or 47 countries. And that is particularly concerned with the issues of access of information, the right of access to information on environmental matters, the right to public participation, and the right to access to justice. And there, of course, the those are very much part of the European Union's philosophy, and indeed the European Union is a party to that convention. And so, and there are others that I'm not going to mention now, but I think it's very important in the European context to be aware of these different strands. Now, that's all I wish to say by way of introduction. I'll just briefly introduce I'll introduce our speakers one by one as we go along. We have first Professor Dr. Luc Lavrazan, who I've had the privilege of working with now for more than 15 years on international environmental law developments, and he is one of the great experts on European environmental law. He's a judge in the Belgian Constitutional Court in Brussels, and also a director of the Center for Environmental Energy Law at Ghent University, where he's a professor of environmental law, and he carries out courses in environmental law at various faculties. And he and I, along with Antonio and others, have been part of the process of establishing the Global Judges Institute, of which you have heard. So we go back quite a long way, and it's a particular pleasure for me to be introducing him to talk about the relationship between the European Court and the national courts of the European countries. So over to you, Luc.
Thank you. So, thank you very much, Lord Cornwall, for this kind introduction. So, during my presentation, I had the intention to introduce those of you which are not coming from Europe, to introduce them in Europe, its institutions and its court systems, because I can imagine that from time to time it seems to be something complicated. So let's go first to the European level, and I would like to present in the first place to you the European Court of Human Rights, which is, as already mentioned, based in Strasbourg in France, and you see the court building on the left side. And as Robert Cornwall mentioned, it's part of the Council of Europe. Council of Europe being an international European organization with 47 member states, being all European countries except one, Belarus, and including also the Asian parts of 2 European countries, being Turkey and Russia. And here you see the court in action and the logo of the court, which is, as you can see, inspired by the building in which the court is sitting. And as already mentioned, so the European Court of Human Rights is dealing with the European Convention on Human Rights dating back to 1950, and its additional protocols which have been added over time. There are now 16, some of them adding additional fundamental rights to the convention, others dealing with some procedural institutional rules. But for the moment, there is no explicit right to the protection of the environment in that European Convention on Human Rights. And the European Court of Human Rights is competent to judge allegations of violations of that European Convention of Human Rights. And so victims of such violations can complain with the court on condition that they have exhausted national remedies, that there is no further appeal possible in their own country. And the court is attracting a large number of cases every year, between 40 and 60,000 cases. Most of them are disposed in simplified way because not admissible, clearly not funded, etc. But of course, there are serious cases also which result in judgments. And the court is working in 2 languages, English and French, and the whole case law can be found on the website in the UBOC database. Let's turn now to a second European court, the Court of Justice of the European Union, formerly also now called the ECG, the European Court of Justice. Since the Lisbon Treaty, it's the Court of Justice of the European Union. For the moment, we have 27 and a half member states because, as mentioned already, the United Kingdom has, for the most part, left the European Union the 1st of February of this year. And now the negotiations are going on to see, because this is an arrangement for 1 year in which the United Kingdom is still bound by European law and is submitted also to the jurisprudence of the Court of Justice, which is based in Luxembourg. And you see on the left side a picture of the buildings of the court. So now the question will be what agreement will be made for next year. And here you see the court in action together with the logo of the court. And the court is reviewing the legality of the acts of the institutions of the European Union as to ensure that the member states comply with the obligations under the European Union treaties, including the European Charter of Fundamental Rights. And it interprets European Union law at the request of national courts and tribunals through the so-called preliminary rulings procedure. So when a national judge is confronted with a question of interpretation or validity of European law, including European environmental law, then the court can, or in certain instances, is obliged to refer that case, that question to the Court of Justice in Luxembourg. And as already mentioned, there is a very large body of European Union environmental law created the last 40 years. The court is working in all official languages of the European Union, that are 24, and the court has around 1,800 cases a year, and also that case law can be found in the database of the court on internet in all of these official languages. Let's look now to the different legal systems in Europe, and then you will notice we have different traditions within Europe. We have in the first place some civil law systems with different variations. We have the French influenced civil law system with France, Belgium, and other countries. We have the more German influenced systems. We have the more Scandinavian, which has particular features. Then we have common law in England and Wales and Ireland. And then we have some systems with a mixture, which is the case in Scotland, Cyprus, and Malta, for example. Let's turn now to the national courts. And of course, it's impossible for me to present to you all the court systems in 47 or 48 European countries. So I have chosen to present to you only courts systems from the countries which are represented in our panels today and next week. And in the first place, the two moderators of the webinars are coming from the United Kingdom. So on the left side, you see a pictogram of how the court system in the UK has been construed. On the top, we have the Supreme Court, which has replaced some years ago the low lords, and then the next level is the level of courts of appeal. And I've shown here a picture of the Court of Appeal of England and Wales, and also the court in action while deciding the recent climate change related case on Heathrow. And of course, below that, you have some inferior courts. Let's look then to my own country, Belgium. There we have a different picture. In the first place, we have a constitutional court. That's a court which is only dealing with constitutional issues, a specialized court for constitutional issues in the tradition, let's say, of Hans Kelsen, who was the origin of the first such constitutional court in Austria in the 20s. And then we have two separate judiciaries, so to speak. On one side, we have what we call the ordinary judiciary, dealing with civil and criminal matters on three levels, with on the top the Supreme Court, or Cour de Cassation as it's known. And the other judiciary is the administrative judiciary, dealing with review of administrative action, with on the top of it the Supreme Administrative Court. In our case, it's called the Council of State. A similar picture you can find in Germany, also there, a specialized constitutional court, the constitutional court of the Bundesverfassungsgericht. And then we have the ordinary judiciary and the administrative judiciary. A part of that is a little bit more complicated than in Belgium, because we have three more specialized Supreme Courts for financial matters, for social matters, and so on. But let's say for environmental issues, the most important is the ordinary judiciary, dealing with civil and criminal matters, with on the top the Federal Court of Justice, the Bundesgericht, on the one side, and then the Federal Administrative Court, the Bundesverwaltungsgericht, being the courts dealing most of the time with environmental issues. Third is Sweden. No constitutional court over there, but the Supreme Court, so comparable with the United Kingdom. But in Sweden we have a particular feature, and these are the specialized environmental courts. We don't have much specialized environmental courts in Europe, but an exception is Sweden, with 5 land and environmental courts over the country, and 1 land and environmental court of appeal based in Stockholm, and these are courts specialized in environmental cases. Let's turn now to France, comparable with Belgium, or just the other way around, as you like it. Also here, a specialized constitutional court, which in that case is called the Conseil Constitutionnel, an ordinary judiciary with on the top the Supreme Court, the Cour de Cassation, and an administrative judiciary with on the top the Supreme Administrative Court, in this case the Conseil d'État. Finally, I would like to present the Netherlands, because next week you will have also a presentation from the Netherlands, and it's well known from the Urgenda case, of course. There we have no constitutional court, no specialized constitutional court. Even in the constitution, there is an interdiction for judges to review constitutionality of law. So that's that's not possible. But also here we have Supreme Court, which has last year decided the Uganda case on a final stage. And we have also here specialized administrative courts and the ordinary judiciary with district courts and courts of appeal. And for the administrative courts, we have an administrative division within the district court and a supreme administrative court, which is called Raad van State, Conseil d'État. So with that, the idea was to give those of you who are not familiar with Europe and its court system to give a flavor about the court system we have in Europe. So thank you for your attention. Stop share. Yeah.
Okay, let me interject. Thank you, Luc, for your Justice Lavriesen, for your wonderful remarks. That was a wonderful overview. This is Denise Antolini. I'm your host, coming back in because Lord Robert Carnworth had to jump off for just a minute. So on his behalf, thank you. That was an excellent education on the various legal systems that form the foundation for our webinar today. So thank you very much. And let me introduce the next speaker while we're waiting for Lord Robert Carnworth to come back on. So Dr. Birgit Peters currently works at the Faculty of Law at the University of Rostock. Birgit does research in public law, international and European law, and on the foundations of legal and political theory. Their most recent publication is Unpacking the Diversity of Procedural Environmental Rights, the European Convention on Human Rights and the Aarhus Convention. This fall, Dr. Peters will be joining the Faculty of Law at the University of Trier. Birgit, would you please take the floor? Thank you.
Yes, thank you very much, Denise, for this kind introduction. And I'm very happy and honored to be part of this session and to be able to talk a bit about the European Convention of Human Rights and the Environment. I named my talk today Limits and Possibilities because the European Convention has had quite some recent highlights in the jurisprudence of national courts. And I'm trying to flip it. Yeah, it is. Very good. And the European Court has been introduced aptly by Luc, so I won't go into the details much of this court. I will concentrate on the jurisprudence of the European Court of Human Rights and the Environment. And most recently, the European Convention of Human Rights, which is the basis for the jurisprudence of the court, has been adjudicated in quite a few and exceptional cases at the national levels. So this has been the idea to take this as a starting point for my talk. What are the limits and possibilities of the court in environmental cases? And you see two pictures on the right-hand side of the slide. There is the Irish case of the Friends of the Irish Environment before the Irish Supreme Court, which Luc hasn't mentioned here. And it's been on the application of the European Convention of Human Rights in the climate change case. And we also see the logo of the Uganda interest organization, which has won a case before the Dutch Supreme Court, claiming that the Dutch government didn't live up to their climate change obligations, and also under the European Convention of Human Rights. And those two cases were quite spectacular. So I wanted to highlight the importance of the court in future cases concerning these issues. The court hasn't itself had a judgment on a climate change case yet, but since we are seeing such a large number of cases coming before the national courts, it's only a matter of time that the European Court of Human Rights will deal with such a case. I wanted to talk today about the following 5 aspects. I want to present a bit the jurisdiction of the European Court of Human Rights in environmental cases. I want to show the bandwidth of European Convention rights involved in environmental cases, because there's quite a lot of cases that the court has tackled. And I want to introduce some of the obligations of member states under the European Conventions that pertain to the protection of the environment. I'll also address some of the justifications why states might be justified in not assuming or adopting some measures, and I will conclude. Now, starting with the first aspect, it shall tackle the question, is the ECHR a means of environmental protection? We are talking about a human rights convention, and so we need to be aware about the jurisdiction of the court and the limits of this jurisdiction. Article 1 of the European Convention on Human Rights says quite clearly that the high contracting parties should secure everyone within their jurisdiction the rights and freedoms defined in the convention. So we need to be aware about what is the jurisdiction of the court, and who can be everyone, who can raise claims before the European Court of Human Rights. And I want to address the matter of jurisdiction in the classical international law criteria: personal jurisdiction, subject matter jurisdiction, and territorial jurisdiction. So Article 1 of the ECHR, starting with the personal jurisdiction, speaks about everyone. And this is clarified in the article which addresses the applications to the court as individuals. So it is quite clear from the convention that not nature per se is allowed to bring claims to the European Court of Human Rights. This is different in other European human rights systems, not in other European and other human rights systems. The Inter-American Court of Human Rights, for example, in 2017 has had a very famous advisory opinion that the judges consider it also possible that nature can be in future cases a legal subject claiming before the Inter-American Court of Human Rights. The court has also, now the European Court of Human Rights, has also made quite clear that there is no popular action, even on behalf of the environment. No one is allowed to bring claims where just their general interest in nature protection, in biodiversity protection, climate change protection are at stake. However, the court has affirmed that environmental interest organizations may claim and apply to the court because of their particular importance as watchdogs for nature. So there's a slight opening for more general claims concerning the environment before the European Court of Human Rights, but it's not sort of a general environmental court, the European Court. Now talking about the substantive matter of jurisdiction. What is the actual matter that the court can decide? Also here, we must be quite clear about the fact what the convention itself says, and Article 34 again, which tackles the admissibility of claims to the court, talks about the violation of the rights set forth in this convention. So it's absolutely necessary that applicants who take a claim to the European Court of Human Rights make clear that the convention rights have been violated. And we've heard now from several participants, above all Robert Cranworth and then Luc Laveson, that the European Convention on Human Rights does not guarantee a right to a clean and healthy environment. That's quite important because other regional human rights instruments do. Above all, the Inter-American Convention on Human Rights, they have a special protocol on that, and the African Convention on Human Rights also guarantees a right to a clean and healthy environment. The European Convention on Human Rights, on the other hand, guarantees mostly civil and political rights, what we know as classical liberties. And it also guarantees just a few so-called social and economic rights. So there's no right to water and no right to health guaranteed in the European Convention on Human Rights. So that's quite important. So the court has to be inventive in a form to tackle claims that belong to the environment. Now, speaking about the territorial jurisdiction, this is also something that limits the actions of the court because the court is confined to the region of the wider Europe. The European Convention has 47 member states, and those member states have to have jurisdiction. That is also part of the convention, and the member states have to have jurisdiction and influence over the acts that concern the environment. The European Court of Human Rights has interpreted that to be mostly territorial. So only on the territory of member states the court allowed the European Convention to apply. This is very tricky in climate change cases now because the negative effects of climate change occur outside Europe. The global south is much more affected than Europe itself when it comes to climate change. So there needs to be a way around this to interpret possibly the European Convention in the broader form. And there's an entry point into this. The court has held in exceptional cases that the convention can also apply extraterritorially, mostly concerning the aspect of state sorry, I was reading a question that was posed to me. I'll come back to that question later. State agent authority and control, and where states have control over enterprises, for example, as the Trace Matter arbitration has held in international law, there could be an entry point that the European Convention also applies extraterritorially. But then the enterprise in question, for example, emitting CO2 emissions, must be under the control of the state in the sense of that jurisdiction. Now we've established the jurisdiction of the court and its limitations, and now I want to come to the aspect of what is the actual obligations under the European Convention. And I want to present some of the cases that tackled the environment. The court has held a large number of cases and also a large number of rights can be invoked in environment matters, and almost every civil and political right that's contained in the convention has been invoked in environmental affairs. The court has dealt with Article 2, the right to life, in very important cases, for example, in a Yildiz case that concerned a methane explosion in a landfill where the applicants were actually descendants of some that had been killed by this explosion. In the same case, the court also addressed the right to property, which is guaranteed in Article 1, Protocol 1 of the European Convention. The court has dealt with the prohibition of torture, which seems quite exceptional that this can be invoked in environmental cases. For example, in the Brandusa judgment, which concerned passive smoking and the exposure to passive smoking. The court has dealt with the right to family life, especially in the Hutton judgment that concerned noise emissions by Heathrow Airport. The court has tackled the right to a fair trial, and the right to Article 10 concerning the right to information has been invoked in quite a few cases where environmental interest organizations claimed their right to environmental information. So there's a huge bandwidth of obligations that's been involved in environmental cases. And now if we consider, okay, there's a number of cases where the rights have been involved, what are the kinds of obligations that states are owed with under these articles? The court has made it clear that it's mostly about the obligation to protect the rights contained in these articles. And the obligation to protect has two distinctive elements. On the one hand side, we have substantive elements, how to protect the rights, the right to family, the right to life, mostly by adhering to the international environmental obligations that we know from international environmental law. So the court has held that states must ensure that there's no harm being done to the applicants, that they adopt precautionary measures, and that they accept that the polluter pays for their pollution, for the pollution they've been caused. Much above all, the court, however, has also accepted their procedural obligations as part of the duty to protect. And the first most important procedural obligation is the obligation to conduct an environmental impact assessment, to give applicants information about environmental aspects, to involve applicants in environmental decision-making procedures, meaning participation, and to guarantee their access to justice in environmental cases. And I guess Jan Darker will go into the further details of this, but this is mostly the court accepting the basic rights that are also guaranteed in the Aarhus Convention. The convention guarantees mostly those procedural environmental rights. And now we have sort of found now the scope of obligations under the convention. Now we must consider the standard of proof. And this is quite high actually in environmental cases. Applicants have to make sure that they prove a real risk of damage to their individual rights or some negative influence on their rights. The court has held several times that it must not be too distant that there are environmental rights at stake. For example, there were cases involving the influence of mobile phone antennas, and the court has held that there's no real risk of damage there. And also applicants have tried to make claims concerning the protection of the beauty of a natural reserve next to their homes, and the court has made clear this is not the case either. Now, concluding, there are further restrictive elements where states are, can make justifications for not adopting certain measures to protect the environment. The court has made quite clear that when it comes to those obligations to protect, states have a margin of appreciation to really decide on the measures they want to fulfill to guarantee the rights in the convention. The court has also made clear, especially in the Hutton judgment, that this margin of appreciation includes the capacity of states, the economic capacity of states to fulfill the obligation. And now concluding on the actual scope of the European Convention, it's becoming quite clear, I think, from what I've said before, that the European Convention of Human Rights provides an anthropocentric form of environmental protection. It hinges on the protection of individual rights. So far, only living human applicants have been able to make applications before the court. The acts and omissions of the states must be attributed to the state. This is also quite important, and states are encouraged with a margin of appreciation of what measures they can actually, they're actually able to adopt, protecting the environment and the applicants. So I'm looking forward to your further comments and questions, and I'll stop here.
Thank you, Birgit. My apologies that I wasn't there to introduce you. I'm afraid something cropped up here, but I was able to catch up with that very interesting and very succinct survey of the European Convention jurisprudence. And it'll be interesting to hear people's questions about how the limitations, I think, of the European Convention as an instrument of environmental protection. But we'll now move on then to our next speaker, who is Dr. Jan Dapo. He is a professor of environmental law. His research focuses on environmental procedure, water law, and nature conservation. And since 2008, he is the chair of the Task Force on Access to Justice under the Aarhus Convention, of which we have been hearing, and he will be speaking about the relationship between the EU and the Aarhus Convention, which really follows on very from what Birgit's been talking about. So over to you, Jan.
Thank you, Judge Conworth, for this introduction, and I will focus not only on the Aarhus Convention, but mostly on the legal situation in the European Union on access to justice in environmental decision-making. That is, among those 27 and a half, or still 28 member states of the European Union on a higher level, so to speak. But first of all, I would like to highlight two things, two issues which I think is vital in this context. First of all, environmental law, environmental rights, and interests is quite complicated to define, as environmental law is a very wide field of law, covering nature resources planning, industrial installations, species protection and nature conservation, chemical waste and land use issues, communications, etc., etc. So standing in environmental rights, access to justice, and all those specific fields cannot be easily solved, but you have to really look into each field of environmental law to get the full picture. The second issue that I would like to highlight is that sometimes you can hear that not all the member states of the European Union have the environment as a within the constitution and surely not as a constitutional right. And then again, it's important to point to the fact that the two treaties of the European Union do have the environmental protection as a major interest. We have Article 37, we have Article 3 of the Treaty of European Union, we have Article 3, we have Article 11, we have Article 191. setting the basis for the constitution of all member states, as the Treaty of the European Union is ranking higher at the constitutional level compared with the member states' constitutions. So this way, in all of the member states of the European Union, we have the environmental protection in all its aspects. Talking about access to justice, it goes back to Principle 10 of the Rio Declaration from 1992, the 3 pillars in Principle 10 of the Rio Declaration. Right to information, public participation, and access to justice. In 1998, this was developed into the Århus Convention, and the European Union and all its member states are parties to the Århus Convention. And this mixes into EU law into a very strong instrument for access to justice. And also we have express provisions within the European Union law, that is Article 47 of the EU Charter and Article 19 of the Treaty of the European Union, which together forms the principle of effective legal protection. And in addition to this, we have today a huge body of cases under EU law concerning Århus issues. We have today more than 40 cases creating a body of case law, which is quite far-reaching when it comes to the possibilities to challenge administrative decision-making concerning the environment. This is a picture of the most, in my view, today the most important cases in the European Court of Justice concerning access to justice. And these cases concern different aspects on access to justice. Of course, NGO standing, that is standing for environmental non-governmental organizations. We have a case concerning Germany on the same issue under the German principle of Schutznormtheorie, and we have effective remedies, and we have the importance of Article 47, and we have also the doctrine of direct effect. And I will highlight, in my view, the four most important cases for the understanding of the state of affairs within the Union today concerning access to justice and the different aspects. The first of these cases is the Slovak Brown Bear case from 2011, where the Court of Justice expressed that it's a union. It is a union law obligation to understand a certain provision within the Århus Convention in a way, in connection to EU law, in order to enable for environmental NGOs to challenge before a court a decision taken following administrative proceedings liable to be contrary to EU environmental law. This case in 2011 had an immense effect all over Europe, as most member states have an open provision concerning standing, who is able to challenge a decision by the administration concerning environmental protection. And as they have an open provision on standing, the Court of Justice tells the national courts to understand those provisions in order to enable for the NGOs to challenge the decision-making under a certain provision of environmental protection or nature conservation or what have you. So this Slovak Brown Bear case from 2011 was effective in Germany, it was effective in Scandinavia, it was had effect in the Netherlands and in France, etc., etc. In all member states where standing was confined, this was sort of the first key case opening up the field of environmental law to enable for environmental NGOs to challenge in court the administrative decision making. The second case, the Trianel case from the same year, where the Court of Justice defined rights, meaning that rights capable of being impaired must necessarily include the rules of national law implementing EU environmental law and the rules of EU environmental law having direct effect. So the meaning of this sentence is that if you have a certain provision on environmental protection, species protection, water protection, water management, etc., the NGOs must be able to challenge any decision making under those provisions. So this is, in the view of the Court of Justice, this is a right capable of being impaired. So I think it's important to understand that under EU law, the concept of right is quite different from the concept of right under the European Convention of Human Rights, because rights in EU law context is certain provisions concerning the environment create rights for environmental non-governmental organizations. And lastly, a quite recent case from 2017, the Protect case, where the Court of Justice mixed together one article in the Orix Convention together with the Article 47 into an instrument that always require for the national courts to let the NGOs challenge certain decision making of environmental law. So irrespective if you have a provision on, about access to justice in the national legislation or not, the national court must allow members of the public and their organizations to challenge, in this example, certain decisions under the framework, the Water Framework Directive. So these three cases sort of open up the field for environmental NGOs in order to make them, enable for them to have standing in court to challenge decision-making of environmental law. But one thing is to actually have access to courts, and another thing is what can you actually gain when you once have reached the court. And in some member states, the review is quite formal or has been quite formal. And this is why this case, East Sussex from 2015, is quite important, where the Court of Justice states that the court, the national court, must be able to apply effectively the relevant principles and rules of EU law when reviewing the lawfulness of a certain decision under EU law. So far, the Court of Justice requests for the national courts to actually look into the case, look into the substance of the case, and do a rather intense review of the decision making. But even so, so far one can actually say that the combination of Orix Convention and the principle of legal protection under EU law creates a situation which is quite far-reaching when it comes to access to justice. Meaning that if you have a certain provision in EU law, in a directive, for example, which is unconditional and precise, and we have those provisions in Habitat protection in the Habitats Directive, we have them in water law, we have them in waste law, we have them concerning industrial installations, we have them on EIA and so forth. If you have a certain provision which is unconditional and precise, then it's up for the national court to apply those provisions directly and over national law. They are required by the Court of Justice to disapply or set aside any national law in breach of that provision, unconditional and sufficiently precise. And the possibility to go to court and ask the court to disapply a national rule in breach of EU law is awarded to the NGOs. So therefore, one can say actually that those provisions carries rights and obligations for environmental NGOs. And this is, in my view, far-reaching and a very radical concept if you compare with at least some of the member states of the European Union. But then again, we have loads of other questions concerning access to justice. We have, what I have been talking about is the standing issue, standing for individuals, groups, and NGOs. But then, of course, the effectiveness of access to justice is also quite an important question. The duration of the court proceedings. If it's possible to ask for suspension of a certain decision when you appeal that decision. If you are allowed to ask the court to injunct the decision, or as we have many cases, you may be right in court, but when you have your victory in court, the installation is already built, the habitat is lost, and the waste is exported and so forth. And then, of course, we have the last question, which is quite important in the common law jurisdictions, but also in quite a few of the other member states, such as Germany and so forth. That is the cost issue. We have court fees, we have costs for lawyers, we have costs for experts, where the losers pay principle is widely applied. We have bonds and we have issues concerning legal aid. So of course there are way more questions than only concerning standing, which I have been talking about mostly today. This is a slide about other factors that may have an impact on how you can evaluate access to justice in the member states concerning the relationship between the authorities and courts. What kind of action can you actually initiate? What kind of court can you actually go to? Do you have an ordinary general court? Do you have administrative courts? Or do you have even environmental courts? And of course, in what way are the courts equipped with expertise? Can they rely on expertise of their own, as in my own country, or we have to rely on different experts, and the cost of the experts in those cases is of course very important. And of course, what can the court do? Judge Carnwath mentioned this air quality case in London, which is quite illustrating that the court actually can ask the administration to take a new decision and come back to the court and inform the court about the outcome of that decision for the court to control. But that is also very far-reaching court control, and this is also a field where we have great differences from one member state to the other. And lastly, let me just highlight, we have recent years, we have had a debate on rights of nature, rights of animals, rights of trees, etc. And in my view, this is very interesting, but also I think we must, in a European context, what is the added value of that concept? what kind of representation would we have in order to bring about rights of nature, and what is the role of the administration and in relation to those who are awarded this role to represent nature, and what kind of legal action can you actually bring about, and what can you obtain in such an action, the intensity of review, the enforcement, the cost, and also the role of the indigenous people. I think all these issues concerning rights of nature are very interesting if you compare them with the legal situation in the European Union, where I think we have quite a few, I wouldn't say answers, but at least we have a system which tries to answer these questions concerning rights of nature. But this, of course, can be debated. So I think this debate is very interesting. It will be interesting to follow how it plays out, as the European Parliament has recently highlighted this issue and wants to have an investigation as to which news will be brought about by this concept of rights of nature. I think that is just about it for now. Thank you.
Thank you very much, Jan, for that overview of what is actually quite a complicated subject, and the concept of access to information, public participation, access to justice is very simple and I think very strong, but it's, as you made clear, it's been sort of worked out in different ways through the European community and through the courts. And I think that's a very interesting topic which would merit further discussion. But we now move on then to our last speaker, that's Judge Marc Clement, another good friend who I've shared many platforms with over the years, and he is since 2014, he's been a member of the French Environmental Authority, previously in charge of infringements, and he has also served as a legal advisor to the European Environment Agency, and he is going to speak about impact assessments and public participation, new horizons proposed by the CJEU. So over to you, Mark.
Thanks a lot. Thanks very much. I'm just sharing my slides. I think it's okay. Yes. So thanks a lot for the invitation and inviting me to talk about this very important topic of public participation and impact assessment. I will present things in the perspective of the Aarhus Convention as well, because I'm also a member of the Aarhus Convention Compliance Committee. I will try to limit the number of references to cases from the Court of Justice, although there is a huge amount of case law, as Jan previously also mentioned in the context of access to justice. We have also a large number of cases related to impact assessments and public participation. So let me, So the main issue is environmental democracy, and talking about environmental democracy, we are referred to the possibilities for the public to access to environmental information, to participate in decision making related to environment, and then to access to justice if needed. These are the three pillars of the Aarhus Convention, and as Jan already said, the Aarhus Convention is really part of the EU law for two reasons. One is that every member state is a party to the Aarhus Convention, but also the European Union is also a party to the convention, and because of that, the treaty makes this Aarhus Convention part of the EU law. These aspects of environmental democracy are really stemming from the Principle 10 of the Rio Declaration that was already presented several times by previous speakers. And based on that, from basically 85, as it was said, with the first environmental impact assessment directive, the EU has developed quite a substantial number of directives and regulations, and also based on these, as I said, there was a substantial set of case law developed by the Court of Justice on the initiative of, many times on the initiative of the national courts, referring cases to the Court of Justice. So, public participation in which decisions? Basically, there are three layers in decisions. The very obvious layer of decisions is the level of project permits for developing a project. That could be, for instance, like on the picture, a road or a plant. And this is the first obvious step. This is now covered by Directive 2011/92, which is a recast of the initial directive from 85. In these projects, you've basically two sets of projects. One set is the big projects where you absolutely need impact assessment and public participation. And there are other projects where you do a first evaluation whether you need an impact assessment and you require public participation or not. And then you have the impact assessment, the public participation takes place, and then the authorities grant the authorization, the permit or not, based on the debate. This is clearly the way, as Justice Benjamin said, this is a very important step if you want to collect information, science, knowledge about the impact of the project on the environment. And this would be also crucial at the level of the court, because you will already have, regardless you have experts or not in the court debate, you will have, because of this impact assessment first and public participation, you will have information provided to the authorities and then later to the court if needed on the scientific impact on the project or the social impact on the project. So that's the first layer, project consent. Then you have the level of plans and programs, where you have documents like typically in the context of urban planning, where you will have big plans allowing later to have individual decisions like development of a plant or road development of roads or permits for housing and things like that. So this is covered by Directive 2001/42. And then you have a third layer, which is non-legislative regulatory acts, where you don't have a directive. If each of these different levels is covered by a different article in the Aarhus Convention. For projects, this is Article 6. For plans, this is Article 7. And for executive acts or regulatory acts, this is Article 8. So, key issues at the Court of Justice in terms of case law, just to give you a set of examples of case law related to these different aspects. crucial issue for projects is the limits of the projects. Usually, developers tend to limit the boundaries of the project because it will make things easier in terms of development of impact assessment. And you will see little impact if you consider the project being limited to one aspect of the plant or one aspect of the development of a big infrastructure project. This was, for instance, the case in the context of the first case I mentioned, 2007, Abraham, which was about an airport, and the question was to know whether modification of the airport with some in specific context, I'm not detailing, amounts for the need for a new environmental impact assessment. Or the one thing which is also very often debated is the adoption through a legislative process of a set of projects where public participation is limited. In the context of the directive, it's allowed to have limited public participation when you adopt a project through a legislative process, because the legislative debates have taken the role of the public participation. That's for projects. As regard plans and programs, one crucial point mentioned by the Court of Justice is the role and independence of expertise when you have two different levels. One, the evaluation of the impact assessment, and the authority in charge of taking the decision. Both have to be completely independent bodies, or relatively independent bodies. And then that's the point of my talk, the limits between regulatory acts and projects or plans. This is a very interesting evolution of the court, which started in 2016 in D'Outremont case. In this case, the court ruled that something looking like an executive act from a Belgium region is to be considered as a plan and program, and then means that you need to do an impact assessment and you need to also have public participation. At the time of this ruling, the question was to know whether this was an isolated case or something which would be confirmed by the Court of Justice. And this year, in June this year, the court in a Grand Chamber case, judgment, so very strong case law, ruled that almost a very similar situation in Flanders region, then a non-legislative regulatory act imposing technical requirements on windmills, such as the level of sounds, the level of shadows that are allowed for windmills permits. In this context, this government order is to be covered by the plans and program directives, and means that you need to have an environmental assessment and you need to have public participation. And I think that this is clearly showing that the Court of Justice pushes for a very broad interpretation of the concept of environmental democracy. And I think that this could be demonstrated in many, many different cases. To me, the justification is first that we are facing procedural rights. So in this context, you need to provide guarantees to citizens, and you can do that through strong procedural rights. There is also this issue of the precautionary principle, better to make sure that you know more on environmental consequences rather than knowing a posteriori that the project will have an effect. And all these things shows a very, very interesting question, which is the boundaries between the public participation principle and the executive and possibly the legislative powers. What do we mean when we have public participation principle? Does that mean that democracy is to be in the context of environment, taking into account differently the rules related to public participation? All these things are showing that in the domain of environmental law and environmental rights, the role of public participation is to be stronger. It is to be stronger than in the context of other issues, probably because of the fact that we all know that the limits of the planets are really reached now. And because of that, we need to have a very strong debate on the use of natural resources, and this could only be done through a strong public participation. It can not only be done through the normal democratic processes, through representation of people by MPs and other bodies. So that is briefly the different things I wanted to present today. Thank you for your attention.
Yes, thank you very much, Mark, for that presentation of a difficult and interesting and indeed developing subject. So that is the end of our formal presentations, and we now have some time, I think about just over half an hour, for questions. And I think some questions have already come in, but just before we do it, perhaps just reminding ourselves what the ground we've been covering. We had Luc Lavrazan talking about the relationship of the European and national courts, which I think is actually a very important issue, because it's not always been that easy for national courts to sort of come into tune with what's been going on in the European courts. And there have certainly, as far as my jurisdiction is concerned, there have been one or two cases where we haven't seen eye to eye. And of course, it's at the national level in the end that enforceable orders are made. Then Birgit gave us a very interesting discussion of the way European human rights law has developed into an effective instrument of environmental protection, but with real limitations, I think, because it was never really designed as such. And again, that's a very interesting subject for further discussion. And then with Ian Darper, we were looking particularly at the Aarhus Convention. And I think he raised what to me is rather an important aspect of access to justice, with is access to remedies, because it's one thing to have access to a court. It's quite another thing to have access to effective remedies. And I was interested, he mentioned a case in which I was involved in the UK Supreme Court, where we were able to order effective action by government. And then Marc Clement has been looking at the very important issue of environmental impact assessment, and at what point the public comes into the picture and to what extent it's listened to. So anyway, I've now got some questions we've been receiving, and happily I have someone who's very kindly forwarding them to me. And the first question I have is for Professor Birgit Peters, and it's this. Birgit, if you're listening, you mentioned that there's an opening for environmental organizations to have standing before the European Court of Human Rights. Has there been any jurisprudence allowing watchdogs of nature in inverted commas, to bring a case to the court? Can you help us on that?
Yes, thank you very much. That's quite an easy question to answer because the quote, "watchdogs of nature," is actually from the court itself. So if I can, I just share the slide again with you where I had the different cases. And one case where the court explicitly referred to watchdogs of nature is this Latvian case, Vidēji clubs against Latvia. And it concerned the rights of an environmental interest organization to retrieve information about an environmental project. And the court emphasized that the organization is actually able to make that claim before the court, and they are to be understood as watchdogs of nature. And there's also another case against Belgium, L'Érabilière against Belgium, where the court made the same quotation. So that is, these are the two cases I can quote on that.
Thank you very much. Does any of the other panelists want to comment on that, or shall we move on? No, I think we'll move on. And I've got a question for Professor Darpo. On the issue of access to justice, what would you say are the criteria to assess how effectively access to justice has been implemented into the national court systems? Can you comment on that?
I guess I cannot. How would you be able to evaluate access to justice? You have to look into case law of the national courts to see whether they have how many cases are there, have they been successfully brought, what have been obtained in those cases. And then again, it's a big difference between different countries. To make a simple comparison between Finland and Sweden, Swedes always complain to court. We have very similar systems. Finns never. So you have to have cases, you have to have similar situations. And there are quite a few, well, there are some studies as to the effectiveness, and there are cases. You can read about the cases not only on the website that Luc mentioned, but also on the website of the Task Force on Access to Justice. There are quite a few European cases on access to justice. And then again, you need to evaluate, what do you mean by access to justice? It's in some member states, the doors to the court are wide open, but you can never get anything from getting into the court. You can just get a very formal review, whereas in other systems, the doors are quite narrow, but once you're in, you can get the full Monty, so to speak.
Yes. I think it'd be interesting to hear the other panelists, because you've got representatives of 4 European countries. In my own country, we take the view that I mean, the sort of test for judicial review is sufficient interest, but we've said in the Supreme Court that the environment is of interest to everyone, and so anyone who has a genuine issue, it has the standing. What we then tend to do is to say, well, when we come to remedies, we may need to limit the remedies depending on how it affects other members of the public. I don't know whether Luc is there, Luc Leverson, whether you're able to comment on how this works in Belgium.
I think probably in general, one can say that our judges, and also including my court, the Constitutional Court, is implementing the judgments of the court. I think from the 5 cases presented by Marc Clément, there were 4 cases out of Belgium. So, but sometimes, as Jan Darpo mentioned also, justice is slow, and although after some time, let's say a judgment is there which is favorable for the environment, but meanwhile the egg is already broken. So I think that's a problem. So let's say in general, as our judiciaries are concerned, the judiciaries will apply the case law of both courts, the European Court of Human Rights, the Court of, but sometimes a little bit late. So then you can say it's not always effective, because if you have a nice judgment when things are already damaged, yes, then you have a nice result on paper, but not on the ground. So, but for the moment, I think it's difficult to speak for the whole of the European Union, all different countries. There are only limited studies about this, and certainly limited studies in the field of environmental law. That's the reason why next year's annual conference of the European Union Forum of Judges for the Environment will, if it can happen due to the pandemic, it will be just on the follow-up of the case law cases in which there have been references to the Court of Justice, and what is happening then, because the final decisions are taken by the national judiciaries, what's happening there to try to have a better view on that for different countries of Europe, so that there is, it's very difficult. So you have the website, for example, of the Association of Supreme Administrative Courts, but that's not systematically following up the implementation of those judgments. So I think still a lot of work to do on that issue.
Yes, so thank you very much. Does anyone else, do any of the panelists want to comment on that question about access to the effectiveness of access to justice? Right, well, I'll move on to the next question. We have a question for all panelists, and I think Christina is included in this if she's listening. As greenhouse gas emissions from shipping operations and activities are a serious issue in the European Union, what are the panelists' thoughts on the existing regulations to control these emissions? It's rather a different issue to what we've been talking about. Does anyone feel able to comment on that issue, the question of greenhouse gas emissions from shipping operations and activities and how they are brought under control?
Well,
Christina,
I can give it a try, of course. This is a very important question. It's also a very important issue because, as we know, emissions, greenhouse gas emissions from the maritime sector, transport sector, is not covered by the Paris Agreement, and it was not initially covered within the European Union by the emissions trading scheme, which covers a lot of greenhouse gas emissions, but it did not cover emissions from shipping. There is currently an initiative underway to include the emissions from shipping under the purview of the EU emissions trading scheme as a first step. But emissions from European shipping alone doesn't really address the problem because it is not addressed internationally. And there is also an initiative under the IMO, the International Maritime Organization, to find a global framework that addresses emissions from the maritime sector. It's not in place yet, but discussions and negotiations are ongoing.
Thank you very much. Does anyone else want to comment on that issue?
Maybe can I add just something? So I fully agree with Christina, because of course shipping is a worldwide issue, and I think the portion of shipping of ships owned by European companies is just a part of the whole system. I think for the moment, as European Union law is concerned, there is only one provision that is calling for monitoring. I think we are now in the monitoring station that ships which are under the European Union flag must monitor their greenhouse gas emissions, and they have to be reported annually, I think, so that so that the European Union is gaining more insight in the problem. So I think that's and there are some rules about the fuels, but indeed the big discussions will be under IMO, I think.
Thank you. Now I've got a question which really in a way follows on from that sort of issue, and this is addressed to Judge Clement. Is there any potential to see the effects of the principle of public participation in an extra-jurisdictional application? For instance, EU companies have projects with major impacts outside of Europe, which are carried out without public participation. So one's looking really at the sort of role of EU companies when they're conducting activities which have major activities outside of Europe. How does public participation come in there? Mark, are you able to comment on that?
Yes, I think it's really limited, because what we are talking about is a permit granted by an authority, and the law that applies to these authorities is necessarily the law of the EU or the national states. So it means that outside the boundaries of the EU, there will be limited impact of the EIA directive. That could be done through the ESPO convention, but not part of the also part of the EU. But with the transboundary effect of a project, for instance, that's the case we had in the compliance committee of the Aarhus Convention. We have many cases related to nuclear plants. So if you refer to nuclear plants, the project is a project which takes place in a member state, but the effects can be outside the boundaries of the EU. But we don't have a system where we would say, for instance, that a company implementing a project outside of the EU would be required to perform some kind of EU. But it's complicated due to the fact that the permit is granted by a national authority.
Right, well, thank you. Anyone else want to comment on that?
Maybe
Right.
just an additional comment that as investment projects where the European investment banks are concerned, and if those projects are conducted outside the European Union, there is also some obligation to or guidelines about environmental impact assessment and public participation. But it seems that in practice, those guidelines are not very strongly enforced. So I was part some years ago in a PhD research on that. So there is room, I think, for improvement of environmental impact assessment procedures and public participation in cases of investment by European investment banks outside the European Union.
Right, thank you. Yes. I think someone's asking Birgit about, well, I think it's an extension of what you've already been talking about, which is, given the limits of the European Convention in relation to environmental matters, how effective is it in practice in terms of actually providing protection for the environment at national level? I don't know whether you can comment on that. I mean, I know as far as my own country is concerned, I don't think we've ever found ourselves having to depend on the European Convention for enforcement of environmental rights, because on the whole our national laws are sufficiently comprehensive to deal with that. But I suspect in other parts of the countries governed by the European Convention, it has proved effective. Are you able to comment on that at all?
Oh, I can do that, yes. Thank you for the question. I think the convention is quite effective, given the fact and the number of cases that the court actually has decided. The court has decided since the 1990s a huge number of cases on very many environmental nuisances and addressed many, many issues and rights, and especially when it comes to Turkey. Turkey is a frequent respondent before the court. I would say that possibly the court has helped that environmental protection has upped and increased there, just given the fact that yeah, applicants have been quite successful in leading cases against Turkey to uphold the European Convention. Also, the court struggled against the UK in the Hutton case. The first chamber judgment was in favor of the applicants, so possibly then the noise reduction in London should have gone up, and the applicants should have been more protected. But then the second Hutton judgment proved that the UK noise reduction legislation was actually sufficient. But you can say, you know, this has had a great impact. And it has had an impact to the extent that some have actually said the court is protecting the environment as if there was a right to a clean and healthy environment guaranteed in the convention system. The court itself doesn't subscribe to that because there is no right guaranteed in the convention, but still the jurisprudence is so broad that and it has addressed so many obligations of states that one can actually conclude that. So I would say the court is effective. As a matter of fact, the court itself is in Europe quite effective, I would say. And whether or not, yeah, it has done a lot on a broad level, I can't really say because the judgments apply one-to-one. So yeah, whether I haven't really looked into the fact whether, for example, there has been a great impact on the ground after one judgment that legislation has been changed broadly on a specific matter. I can't really comment on that. Thank you.
Yes, I think your comment on the Hatton case is a fair one, because this is a case which concerned night flights over Heathrow. And as you say, although the first court ruled against the United Kingdom, the Grand Chamber ruled in favour, but nonetheless it made clear that there were limits, and I think that has certainly influenced the way policy has developed in the UK, so that's a fair point. I've now got a question from...
Can I just add one thing about human rights courts? I just want to inform that the European Human Rights Court will have a webinar, a meeting and a webinar on the 5th October on human rights law and the environment. So I think it's a full day seminar on human rights and the environment, and I think actually you can just visit the website of the court to see to be invited, just for information.
Well, that's, I think, very useful and something which might circulate the link if we can get it. Right, shall we move on from that? I've got a question for Christina Voigt. How can the World Commission on Environmental Law members support regulatory compliance in the EU, noting that the implementation gap of regulation remains a challenge? That's been directed to Christina. I don't know whether you regard that as something you could deal with.
Thank you. I hope I got the entire question. The implementation and compliance with environmental regulation is not just a challenge in the EU, it's a challenge worldwide. I think that's nothing specific within the European Union. But I think I did read the original question, which focused on biodiversity. And I thought that was an interesting question because biodiversity is a case example of the complexity that we are facing both in legislation, but also in litigation, where a lot of science data is required and has to be understood by those who either make the laws or apply the laws or sit and rule on the laws as judges. And I think the WCL can work with its members to enhance their capacity, to understand the science behind biodiversity decline and also work on what kind of legal responses would be necessary. And also, of course, then work with judges, as we've been doing for quite some time now, on how this can be translated into meaningful judicial action. So enhancing capacity is of course what the WCL has done and will continue doing.
Thank you very much. A question for Jan Darpo. Well, this is quite interesting, really. It's pointed out, of course, that the ECHR agreement, which applies to countries such as Chile, Peru, and Argentina, is very similar to the Aarhus Convention. Indeed, was, I think, based on the Aarhus Convention. And he's asking whether the 20 years experience of the Aarhus Convention has provided an effective consolidation of the three topics of access to information, justice, and participation effectively, and implicitly how that should feed into the experience in other parts of the world.
I think there are quite substantial differences between the ECHR agreement and ORIS. As, for example, there is, as far as I know, not decided to set up a committee, a compliance committee under the ECHR. And the ECHR agreement is also more far-reaching when it comes to environmental protection, and especially focusing on indigenous people, their rights to the environment. I would say that the ORIS today is quite controversial, and Marc Clément can fill me in on this, of course. Quite controversial in many member states, although as for the EU, many other parties to the convention, we have 47 parties to the convention as of today. Within the EU, I would say that this is perhaps a little bit provocative, but it is the combination ORIS and the principle of legal protection that creates this strong mechanism of access to justice, and also what can you actually get out from access to justice. If we only had ORIS, the situation would be quite different. We can ask Christina about that. She doesn't have EU law, but she has ORIS. And in the Scandinavian comparison, Norway is perhaps the country which we have not, I wouldn't say not access to the courts, but you get ruined on the way. It's a little bit that everybody is allowed to live on a fancy hotel, but not everyone can afford it. So I think if you ask, it comes down to who you ask. The NGOs in Europe, or the NGOs in the parties, the different countries to the Aarhus Convention is quite content, although they would say that Aarhus contains 2 pillars and a stick, and the last, the tiny one is the access to justice stick. They think the proceedings are too slow and the progress is too slow. So I think I guess it comes down to whom you ask.
Thank you. Christina, do you want to comment on that? I mean, I was quite interested from the UK perspective. I think the Aarhus Committee has been quite an important influence. I mean, you mentioned, Jan, the fact that that's a particular feature, and I think it's been quite a success in terms of its ability to produce authoritative decisions. And we've certainly held in the UK that those are matters which we take into account, particularly on issues which, you know, the big issue in the UK is a question of cost of access to justice. And we've been quite impressed by the way the Aarhus Committee has dealt with that. I don't know whether that's true of other countries concerned. Or, I mean, in France, do you take a lot of account of the Aarhus Committee?
But as regards the UK, I can confirm what you are saying, because I'm the rapporteur on the compliance committee for the UK cases, and I can ensure you that this is a huge work, given the complexity of the rules and the complexity of the levels. This is really a very, very huge work. But it's not only the UK. I think the Compliance Committee has developed quite substantial case law. What is very important in this context is that the Compliance Committee is probably a unique situation where we have in an international convention a body which can be which can be appealed by NGOs, by citizens directly against parties to the convention. So it has created a number of cases which is quite huge compared to what you see in international justice in general, because we have something like 180 cases so far. We are dealing with various situations in the EU, outside the EU, but also we have substantial cases where the EU itself is involved. And we have not talked about that, and Jan has not referred to these cases, but we have very delicate cases, and I'm also a rapporteur on these cases. So delicate cases where the question at stake is access to justice in the Court of Justice of the European Union. And when I'm saying, I don't want to say too much on that, but what I can say is that the Court of Justice is very active when it comes to the idea of setting rules for national courts or member states. When it comes to the access to justice in the EU itself, I see the behavior a bit being different. I'm not saying more.
Thank you. Are you currently on the Aarhus Committee? I think you said you were.
I'm on the Aarhus Committee.
And you're holding the whip to the UK, I think.
No, I'm trying to collaborate with the UK to make things happening.
Well, keep it up. Can we now? Your time is running out. There's a question about specialization here. In fact, 2 questions really linked. One, to what extent are judges becoming more specialists, not just in environmental law, but also in particular aspects such as water, air, or biodiversity? And to what extent are they having to get on top of the scientist aspects? And linked to that, I think, question in relation to the European Court of Human Rights. How is that able to deal with the scientific issues that crop up quite regularly in the cases? I think Antonia mentioned this in opening. Does anyone want to comment on that? I mean, first of all, Birgit, from the point of view of the European Court of Human Rights, has science been a problem, or how has that been dealt with when you have difficult scientific issues?
Well, I guess it has been a problem, and it had been even in this landmark case the UK against the UK in the Hutton case, because there it was quite problematic to ascertain whether or not noise reduction levels and which noise reduction levels had been adhered to. And in general, science is always, I'd say, a problem in environmental cases, because especially in the human rights regime, you must establish that the risk can actually be attributed to the state. So the state must be responsible for creating the risk in the first place, or not protecting the applicant, and that's quite difficult to prove on behalf of the applicant. So right now, the jurisprudence of the court is that there has to be a real risk on the rights of the applicant, and that the applicant has to prove that, and there's a lot of science involved in proving this. And I made a reference to climate change cases, and this is possibly, I guess, the most difficult agenda now for courts all over the world, where we have individual applicants claiming that their human rights have been violated by states not adhering to the international climate change regime. And there we have a huge problem of really breaking that down to the individual human rights violation.
I think this is, sorry to interrupt, but I think this is probably inherent in the subject. You need to tackle the scientific aspects, but I suspect that different jurisdictions deal with it in different ways. And certainly in my own, we don't have specialist scientific judges as such, but we do rely on experts who we hear giving evidence. And I suspect, does anyone else want to comment on that briefly?
I can just briefly comment. It relates to the question of burden of proof as well that Birgit addressed, and the interesting question, how far could the precautionary principle be applied to reverse the burden of proof, something that has happened in certain jurisdictions but not yet at the European cases, where the requirement would then be that those that want to carry out a possibly damaging activity or harmful activity would have to prove that it's actually not harmful, rather than the opposite, where the applicant has the burden of proof. But this is future developments that we may or may not see, but it's worthwhile considering the precautionary principle in this regard. Right.
Well, thank you very much. I'm afraid I'm going to have to come to an end, but I can't resist the final question I've been given. With Brexit, what do the panelists think will happen with environmental cases, actual and future, between the UK and the EU? I don't know whether anyone wants to comment on where Brexit is going to take us all.
Maybe I would like to say something about specialization, because that was the other questions. So I think there is a huge need for specialization in environmental law, in the judiciary, but also as it comes to enforcement. In fact, for the whole enforcement chain, from inspection over police, customs, prosecutors, and so on. And looking to Europe, we find different degrees of, let's say, more informal specialization in courts, because some sections, some chambers are dealing a lot with environmental cases, but in most of the country it has not been structural embedded, this kind of specialization, except Sweden, also to some extent Finland and so on, and some smaller, like the tribunals in the UK, and some smaller administrative courts, and so in my own country, etc. But I think on this point, specialization of the judiciary in environmental law, although Europe is saying well developed in legislation, environmental legislation is lagging behind other continents in this respect, because in a lot of other continents we see environmental courts, tribunals, specialization, structurally organized, in different ways, going from the nearly 2,000 enforcement courts in China, etc., but different degrees. So my ideal is still the example of the Land and Environmental Court of New South Wales in Australia, where you can combine civil jurisdiction, criminal and administrative jurisdiction all together in the environmental law. But it's difficult to organize this form of specialization in Europe because of strong and very let's say historical grown judicial structures.
Yeah.
It's
Look,
more
I'm going to have to
difficult
stop you there because I'm being told I'm running out of time, which means I won't be able to open my question about Brexit, but I think probably just as well, because I don't think any of us know quite where that's going. Personally, I'm very hopeful that whatever else comes out of Brexit, it won't diminish in any way the environmental protections we have in the UK, or indeed the cooperation we have and enjoy with Europe. And I'm delighted that Luke, the organization, the European Union Forum of Judges for the Environment, which he and I helped set up many years ago, and which he's chairman of, have agreed that the UK can continue to be a member. So that's very satisfactory. Now, I think on that note, I'm sorry, thank you for all the questions. We probably haven't covered everything, but we tried to do what we can. Thank you for our amazing panelists for covering an extraordinarily complex area very succinctly and very attractively, and for answering the questions. And I think that probably completes my role. Denise, I think you're there. Do you want to wrap it up before we finally say goodbye to each other? Over to you, Denise.
Yes, thank you, Robert, to all the panelists, to all the interpreters, to all the staff behind the scenes. You did an excellent job. This was a complicated, complex, and very high-level panel. For the participants who are watching, we will be posting the materials, the PowerPoint and the recording in about a week, so you can continue to review this and digest it. We thank you very much for joining us today for this wonderful webinar. We have another one, as I mentioned, on September 4th coming up, but this is an excellent foundation and a deep dive into some really important issues. So on behalf of the World Commission on Environmental Law, I thank you for joining us today. And with that, I say, have a good day. We wish you well, and we'll see you next time. Bye-bye.